Okay, next we will have Jake Steen, attorney with Lloyd, Gosselink, Rochelle, and Townsend, Demystifying GCD Permitting.
Hello, everybody. It's great to be with you all today. I hope everybody's been having a good summit. Like JJ said, my name is Jake Steen. I'm an attorney at Lloyd Gosselink. I practice in our firm's water, districts, and litigation practice groups. One thing I've been thinking about over the past couple of days here at the summit, talking with friends, obviously it's that time of year. Kids are back in school. I've been surprised to see how excited some of you have been about that fact. I don't have kids. One of the things I'm excited about right now is college football players are going to fall camp, gearing up for the season. I know that the Fighting Texas Aggies are gearing up to beat the hell out of Notre Dame next Saturday. But one of the lessons that's cutting across all of those kids' lives right now is this idea of back to basics. You're getting back into school, you're getting back into fall camp, you're learning about the fundamentals again and what makes the back to basics. And a large part of what my presentation is today is we're going to go through the basics of Texas groundwater law. We're going to talk about the history and the context of how we got to Chapter 36 and the regulations with the groundwater conservation districts today. And one of the other things I'm going to talk about today is the permitting process. Now, obviously, all the presentations today, Senator Perry certainly hit on it today during the panel. Groundwater is a resource that is not only being relied on more frequently nowadays, but it's going to only increase into the future. And it's a contested resource. And folks are going to learn about their rights to groundwater, and that groundwater is going to be fought over. And so I hope that today we can walk through the permitting process, walk through what Chapter 36 says about contested cases, to give you a better understanding, better fundamentals about what to do in those situations, so you can go back home and deal with those situations as they arise. At an outset, though, you can't really understand the law of groundwater without understanding the fundamental distinction in my mind. Surface water. It is owned by the state of Texas. It's statewide regulated by the Texas Commission on Environmental Quality, the TCEQ. It's held in public trust by the state of Texas for the people of Texas. Groundwater, on the other hand, is a private property right. It's owned by the landowner's surface estate, and it's regulated by groundwater conservation districts where they're established. I think as long as we can remember that fundamental distinction, right, everything flows from that key premise, that it's a private property right that we're trying to regulate here. And where GCDs aren't established, there's what's called the rule of capture. In 1904, the Texas Supreme Court in the East case established formally that the rule of capture was the law of the land in Texas for groundwater. It's this idea that landowners who capture groundwater, they acquire absolute ownership of that groundwater, even if it's taken from a neighboring landowner. When I was in law school, one of the professors said it was the milkshake rule. And I always kind of thought that was a pretty good analogy. You know, when I was a kid, one of my favorite memories was on Fridays, my mom would take me to the local neighborhood diner, and I'd get the biggest strawberry milkshake that was on the menu, and I'd get that big straw, and I'd put it in there, and it never seemed like the milkshake would end. It was fantastic. In a large way, that's similar to the rule of capture. You stick your straw in the ground, and as long as you are not intentional about any harms that happen to your adjacent landowner, you're not liable for tort. And when this was established by the Texas Supreme Court, it was really a policy decision by the court. Remind you, it's 1904. There's not the available technology to track, the movements of the water, track really where these aquifers extend to, the depths and whatnot. The court recognized that the movement of these waters, they're secret. And any attempt to try to, administer a set of legal rules around, these moving waters, I quote here, it's hopelessly uncertain and practically impossible. And this was also at a point when the state was looking to grow and develop, and the use of groundwater was critical for the state's agricultural economy, was critical for development in the cities, critical for all sorts of economic activities, and the court wanted to establish a rule that encouraged that development, and that's what the rule of capture stood for. At the time when Texas adopted the rule of capture in 1904, that's basically what every state had, except New Hampshire, the Granite State. They were the outlier. But As it moved on, states moved away from this idea. By 1939, only 11 states followed the rule of capture. By 1960, it was just 3. And ultimately, by 1999, we were the only state left. And today, we are still a rule of capture state. The Day McDaniel case in 2012 qualified that right with the authority of groundwater districts to regulate that property right. But at the end of the day, the rule of capture still stands, and particularly where parts of our state where there aren't groundwater districts, the rule of capture is absolutely still the law of the land. And groundwater is governed by Chapter 36 of the Texas Water Code, and as I just said, subject to regulation by groundwater conservation districts where they are established. As Robert's presentation touched on, there's been some key legislation through the years that have kind of set up the regulatory framework that we now know of today. I think a lot about Senate Bill 1 in 1997 and Senate Bill 2 in 2001. Senate Bill 1 flipped the approach of the state for water planning from a top-down approach on its head. It decided that we're going to do this at a regional level. Senate Bill 2 empowered districts to issue permits and limit use, to establish rules on export permits and spacing requirements, focusing on water quality and adopting water conservation practices and drought management measures at a regional level. I've got a picture here of State Senator Buster Brown. Senator Brown was the author of Senate Bill 1 and 2, and on a personal note, Senator Brown is my cousin. And I take great pride in knowing that a small part of my family's legacy is entwined with the groundwater management and water management in the state of Texas today. On the last point on that, if you have any concerns about why we've set it up like this, or maybe you're upset about it, come and talk to me and I'll pass your concerns to Cousin Buster at our next fishing camp. What is a GCD? Groundwater conservation districts are political subdivisions of the state of Texas. They're the state's preferred method of groundwater management, and they hold a balancing act of a task. You got to protect property rights, but also balance the conservation and development of groundwater in your local area. GCDs are either created by citizen petitions to the TCEQ or by legislation. And as I've just said, areas without a GCD are still governed by the rule of capture. Robert's presentation had a map similar to this, and I just want to highlight that all those areas in white on the map are areas of the state that don't have GCDs. Senate Bill 1 was a large impetus for lots of the state to establish groundwater conservation districts. I think in your presentation you said 61 have been established since 1997, and that makes up a large portion of this map, but still there is so much of the state that is unregulated with regard to groundwater, and still governed by the rule of capture. I want to plug here the TAG GCD Index. It is a phenomenal resource if you haven't checked it out on the groundwater districts in our state. There is a wealth of information on this website, and I highly encourage all of you to take a look at it and learn some of this information. Chapter 36 grants groundwater conservation districts several powers and responsibilities. Obviously, you have the power to rulemake and grant permits and regulate production through those permits. You have enforcement mechanisms to enforce those rules and those production limits. There's responsibilities for research and management, district management plans, developing DFCs at the regional level, and your MAGs. And ultimately, as I'll get into at the later point of my presentation today, as districts continue to get more and more contested applications, handling these contested case hearings at the district level is one of the powers and responsibilities of GCDs. There's a challenge, though. I think any one of y'all who get into public service know that you're not everybody's best friend. Not everybody's going to like you. There's going to be some people who think you have too much power. There's going to be some people who think you don't have enough. Some people who think that you have too little resources, and some people think that a dime is too many resources. At the end of the day, though, you have this balancing act. On one hand, you have to protect the property rights of the landowners and respect their, authority for the highest level of groundwater, practical level of groundwater production. At the same time, though, you're charged with conserving and preserving and protecting the groundwater resources in your district. It's a tricky balance. I certainly don't envy it, but it's something that every GCD has to deal with. And I think an understanding of Chapter 36 and understanding of this history in this context will help guide that perspective. As we all know, districts are already dealing with contested applications at a greater level than ever before, and I don't really see it stopping anytime soon. Chapter 36 of the Texas Water Code gives GCDs the authority to regulate that groundwater production, and that's through the permitting process. You know, an operating permit, as defined in the Texas Water Code, is any permit that's issued by the district for the operation, for the production of a well. Now, I'm going to skip ahead here just a second, and I'm going to come back to these slides. But that doesn't mean that operating permits are the only permits in the district, as you all know. Not all permits are the same, and not all of the considerations that go into an operating permit are the same. You know, if somebody comes in with an application to export groundwater outside the district, there's additional things that the district needs to consider in those applications. There's exempted uses of groundwater for domestic and livestock use, for some oil and gas activities where you don't even need an operating permit. There's historic and existing use permits that are issued at the outset of the district's creation. There's drilling permits, which in a lot of cases districts will make that a separate, complete permit that you got to get before you go get your operating permit. We're focusing on operating permits today, but I just wanted to help provide that context and we don't get lost in all of this information here. Chapter 36.113D is a big statute. It outlines what districts must consider when granting or denying a permit. These are some of the things that you all need to look at and the boards need to look at. You know, whether the proposed use of water unreasonably affects existing groundwater or surface water resources or existing permit holders. Is the proposed use of water dedicated to a beneficial use as defined by Chapter 36? Is the proposed use of water consistent with the district's management plan? Does the applicant agree to avoid waste and achieve water conservation? You know, is the applicant using reasonable diligence that they're going to protect the groundwater quality, and are they going to follow well plugging guidelines at the time of well closure? All these things are things that districts should consider, must consider when these permit applications come through the door. So you're back home and somebody comes through the door and puts in an application for an operating permit. I think the first thing that we all need to walk through here is, does the district require a hearing on this application? If it doesn't, the board or the district GM, if they're delegated that authority, you know, you start walking through those considerations that we just talked about, and you determine whether you're going to grant the permit, grant it with special conditions, or ultimately deny the permit. If it does require a hearing, there's a subchapter of Chapter 36, subchapter M, which details and provides a roadmap for how districts should handle those applications, because there's several things that you need to do, right? You need to put the public on notice. You need to put those landowners who may have, you know, rights that may be affected by this permit application and give them the kind of due process that they need for that right. If an application requires a hearing, the district needs to schedule an initial hearing within 35 days after determining the application is administratively complete. The district needs to provide a notice, as we just talked about, to the public. You know, that notice needs to include information on the well location. You need a brief explanation to alert the public of the requested amount of groundwater, its proposed use, and other relevant information highlighted in the statute. The next consideration comes down to, is anybody going to protest this application? If no one submits a written protest to the district saying they're going to contest, they'd like to contest the application, nobody shows up to the public hearing with issues and that's saying they would like to contest the application, proceed. The board can go through those considerations in 113D and either grant the permit application, grant it with special conditions, or deny it. But if it is contested and somebody comes forward and they say they have real concerns about the permit application, they think it might affect their rights, the board shall schedule a preliminary hearing. to ultimately hear out that person's request and determine whether or not that person has standing. When that person comes forward and they are concerned about a potential permit application, the board needs to determine whether or not that person has raised a justiciable issue, an interest that's related to a legal right, a duty, a privilege, an economic interest that's affected by that permit application. That's within the regulatory authority of the district, but importantly, that's distinct from the general public. It has to be unique to that permit application. It just can't be anybody that comes in and has any other claim that anybody else can make in the district. If the board determines that ultimately nobody came forward with a protest for the contested case hearing that rises to that level of raising a justiciable interest, the board can treat the application as if it's uncontested. But if the board determines that a person has standing, that they have a legitimate justiciable interest, you move forward to the contested case hearing. Now, there's 3 ways that the board can handle a contested case hearing. Ultimately, you can handle them at the board level. The board can hire a hearings examiner and conduct the hearing that way, or you can send it to the State Office of Administrative Hearings, or SOA. The applicant can also come forward and say, I'd like for the hearing to be done at the State Office of Administrative Hearings. That's fully within their rights. Now, if that's the case, the applicant has to pay for all the costs associated with the hearing. They're going to make a deposit at the district. The district will then pay SOA, and ultimately, if there's any money left over, they'll refund it back to the applicant. But one thing I want to stress here is that, for instance, if you send the application to SOA, whether the board decides to do that or the applicant decides to do that, at the end of the day, it's the board's final decision. SOA is going to go through a very formal trial-like process. They follow all the rules of the Administrative Procedure Act. There's discovery. At the hearing, there's all the examinations and testimony. It's very trial-like. And ultimately, at the end of the day, the judge is going to issue what's called a proposal for decision, which is basically the judge saying, here are the facts as I think they are, here are the conclusions of the applicable law, and ultimately, here's what I would recommend that the board do. Now, the board is within their right to modify or even vacate those proposals for decision. Now, you can't just do it without any basis. You got to have authority to say that maybe the ALJ did not properly apply or interpret the law. Maybe they didn't apply the district's rules in the applicable way. But ultimately, at the end of the day, the authority, when it comes down to it, it comes back to the district's board. Now, folks, you can't, the districts, they can't simply rest on those decisions forever. There are timelines here in the Texas Water Code, Chapter 36, that ultimately districts have to follow when issuing those decisions. It's 60 days after the date of the final hearing on the application concludes, or 180 days after the receipt of SOA's proposal for decision. People can appeal. They may not be satisfied with the district's decision. Parties to a contested case hearing have 20 days to request a rehearing if it's done at the board level after they've issued their decision on a contested permit application. But ultimately, if the party is going to appeal the decision, they have to exhaust all of their administrative remedies before taking this thing up to the Texas District Court if they wish to appeal the board's final decision. In closing, I'd like to just touch on a couple of notes here. It is, as groundwater becomes a resource that is relied on more and more and more, and people become more aware of the groundwater resources in their area and the rights that they have in this process, it is so important for districts to not only understand the context of how we got here and the history of how we got to the regulations that we have today, but understanding and having familiarity with Subchapter M, those procedures that Chapter 36 lays out for how to deal with these contested applications in a manner that is fair and judicious to all the parties involved. I think about a lot how, if public notice goes out and having those relationships in your district. You know, if public notice goes out on an application and you know folks in your district are going to be contesting the application, encouraging district staff to meet with those folks and have a conversation and walking some of those folks through. Many people, they get to the district and they may not understand the process. They may not understand all the things that the district is doing to, you know, protect the aquifer and protect their rights. And so giving them that opportunity can help diffuse some of the tension. On the same token, meeting with these applicants and making sure that there is no gaps in the information as you go into the process. It can help a smooth process, and it can help a transition ultimately into an outcome that is in accordance with Chapter 36 and the Texas Water Code. It's a healthy balance of interest. It's a tough job, but I thank you and commend you all for the work that you do. Thank you all very much, and I'm happy to take any questions if you have them.
Can you hear me? Okay. Last year in the state legislature, there was a bill proposed that would limit liability in the case of an unintended CO2 plume migration that would restrict access to drinking water or minerals. And so I'm just wondering where that kind of goes into this like use permit and production permit, and if you've got like could you maybe go into some of the provisions of like what happens if, and are there maybe opportunities or resources for communities or landowners that have sort of had their water access taken from them in these instances? Sure.
I'm not positive about the specific legislation that you referenced, but I'll tell you this, 36113D, those are the considerations and the factors that come into it for that districts shall consider. Obviously, in terms of money that districts can maybe help allocate to address those situations. You know, I think one of the things that we all listen to in the legislative panel is that, you know, the legislators are looking at ways that, you know, we can not only address our water issues, but help, you know, private landowners with their water issues. And it's certainly something that I think the legislative process is going to be dealing with. Clearly, bills have been brought to the floor on this, and I don't doubt that as carbon capture and various things become more relevant in Texas and become more widespread in their adoption, that those issues are going to come before the legislature. So I'm sorry I can't help you answer in the way you want, but that's the best I got.
Thanks. Great presentation that helped clear up a lot of things that I've been confused about for a long time. But one thing I'm still a little confused about is if a district denies a permit and the applicant contests, kind of where does it go from there? Because at the end of the day, it's their private property right to use their water. Could you just elaborate a little bit more of what happens if they contest, and at the end of the day, is it a judge that decides whether or not that permit needs to be amended, or it's accepted or accepted with certain conditions? Just elaborate a little bit more of what happens when you keep going down that road.
Sure. I don't know if you can tell by my lack of gray hairs that I don't have the most experience, but I can tell you it gets appealed up to the Texas District Court level. The judge will determine whether the district's actions were proper in accordance with the considerations that we laid out. Takings claims are obviously brought into the equation here when we're talking about private property rights. You know, folks will, you know, have in the past pursued takings claims when their private property rights they feel like have been denied, their investment-backed expectations have been denied, and certainly, as case law has shown, you know, those can be brought and those can be successful. I hope that answers or helps clarify.
Yeah, it's probably a case-by-case basis, but thanks. Thanks for the presentation. I've always been really confused on
Sure.
this.
Just a quick question. One of the options that the districts have is granting with special conditions. So can you speak quickly or a little bit about the authority that Chapter 36 gives districts for special conditions, and especially on some of the situations where maybe you've got several districts that are over the same aquifer, and yet, you know, some special conditions could be granted in one versus the other. Can you speak to the authority that 36 gives for special conditions?
Sure. I know, for example, in a case that's ongoing right now, still in the Third Court of Appeals, they went through the entire process. They went through the contested case hearing process, and ultimately the board decided that the evidence wasn't there to support the idea that they were going to draw out the amount of acre feet that was requested, right? And that's an instance where the board comes in and ultimately at the end of the contested case hearing process modifies and grants those special conditions on the permit application. It ultimately comes back to those considerations within the board. And people may not be satisfied with those conditions, and they have the right to appeal. They have the right to go up to the Texas District Court and determine whether or not the board acted within their scope, whether they applied the factors that we went through today. And that's a decision ultimately that the court's going to make. It's something that the district just has to weigh when they're looking at a permit application and your risk tolerance of potentially having that overturned and what goes on with that.
Okay, thanks.
Any more questions? Thank you.
Thanks, y'all. Gig 'em.